I also wanted to talk about with you is this case out of the 11th Circuit that I talked about on the podcast this last week that dropped, was it Tuesday? So yesterday. It's called VHV Jewelers v. Garland. It's out of the 11th Circuit, and it's about L visas. And so I know you deal with business visas so much, but sometimes.
Yeah.
And so this case is very complicated. I know L's, but I'm not an expert on L's, but I know L's. But this is a complicated case. But essentially, it says to be deemed an executive, you have to manage managers.
It's a troubling decision. But yeah.
Yeah, right. So you're aware of the decision.
I read the first couple pages on a to-do list, and as soon as I read him say have to manage managers, I said, "Oh God, that's that's horrible." Because the executive is a way to get around some that level kind of stuff, especially for smaller companies for a new office.
Right. And the 11th acknowledges that this is going to be a problem for small businesses. I mean, some small businesses can't afford, right, a manager, probably two managers, and a CEO executive to manage that manager. And then there's got to be employees under the manager, because then what is the manager managing?
Yeah. It's a bad decision because it just ruins the distinction between the manager executive, if there was any, because USCIS adjudicates these L1 so inconsistently that the definition of manager executive doesn't really exist anyways. But now with something like this, and I haven't read the whole thing because I read a couple pages and I'm like, I got to sit down and read this. It's going to be annoying. And so it really decimates the definition of the executive, and all of a sudden, so it just goes for bigger companies that have more people and stuff like that, or could invest a lot of money really quick. For smaller shops or smaller companies, it really hurts them drastically.
Yeah, and it's one of those decisions. It's like 5 pages of regulatory definition. You're just like, oh my God. but executive needs to manage a manager on the 11th Circuit. That is the takeaway from VHV Jewelers, I guess.
And the thing is, like USCIS, one circuit makes a decision to automatically apply it, like the Supreme Court did. It said if it hurts the applicant, so that's pretty much you get one decision like this, it goes everywhere.
You think they know about it in the Los Angeles USCIS office? You think they're applying 11th Circuit case law?
Well, at the California Service Center, for sure they will. And so we deal with L's. I mean, look, they have that Kazarian case, which is, I think, the 9th Circuit. Where is it? But USCIS put that in their policy manual. They just picked that up, and then they instituted against O's too, even though it was a EB1A case, extraordinary ability. So, it could be catastrophic for smaller companies once this goes through the pipeline and people get educated on it. But again, I haven't read the whole thing, so I'm kind of jumping on gun. But it seems like it's a negative direction to go.
It doesn't seem good for non-citizens.
No. And I think someone had posted, the attorney who I filed was an old school immigration attorney who passed away. I'm not sure. And the gentleman's name I forget too. You might know who I'm talking about. I had to save my desktop some here, but I have like a million things on my desktop, so it's almost impossible to find anything. Yeah, it was a trouble. Sorry. So go ahead with your interpretation, because you read the whole thing. If there's anything else you want to add.
No, I mean that's my interpretation. It talks about new office petitions as well, which is I don't think there's that many decisions that talk about new office petitions. So I mean, for what it's worth, there's that, and it is one of those frustrating things in L's, and you see it when you try to go from an L to an E. Like USCIS grants it the first time. Yeah. Finding it's an executive, and then the second time they look at it again, they're like, I don't know, well, we're not going to grant it this time, but it's the same role. I mean, there's just no finality to some of these things. I guess it's because USCIS doesn't even trust itself.
Yeah, especially during Trump's time, the readjudicating these business cases. Someone will have an L that's approved, new office, renewal, or on the third renewal, all of a sudden they're like, well, we don't think you're an executive overseas. We're like, wait a minute, you have believed it so many years. Or if they transfer and become a EB1C, a multinational manager, like for 7 years, you've been accepting this as okay, and all of a sudden you make a switch. Like that kind of consistency itself should be, what is that? When you file a federal litigation, it's not abuse, but it's like arbitrary and capricious.
Yeah, and VHV attorney did bring an APA claim, as you must, but it's not an APA claim if it's not an APA case if, as the 11th Circuit said, it follows the regulations. You can't be arbitrary if it's what the regulations require. So says the 11th Circuit, relying on a Justice Scalia treatise as the 11th likes to do.